Welcome back to our lecture on the Nigerian legal method. Okay, today we are going to look at judicial precedent and the hierarchy of courts. One major feature of the common law practice is the binding effects that cases decided by the higher court should be binding on the lower courts. Okay, this was introduced via the Judicial Act of 1873 to 1875, which brought about the doctrine of binding judicial precedent. That is the authority where the authorities of the superior courts were harmonized, demarcated, and firmly settled, saying that the courts of lower jurisdiction should follow the decisions that have been made by the courts of higher jurisdiction. Okay, so the doctrine of judicial precedent, or stare decisis as it's also known, simply imply that courts should stand by what has been decided, or that a court is bound by the decision of a superior court within the same legal system. Okay, so the decision of the Court of Appeal is binding on the decision of the High Court. High Court cannot go against the decision of the Court of Appeal. Court of Appeal cannot go against the decision of the Supreme Court. Okay, so in a loose sense, this simply implies that whenever a court gives decision or a judgment in a given case, it forms a precedent that is what should be followed in other cases that have similar circumstances, similar material facts, and so on. Okay, so what are the major features of judicial precedent? One is that it gives an indispensable foundation for deciding what the law is and how it is applied. So if the Supreme Court rules that this is what the law is, then other courts are expected to follow, because it therefore defines what the law is. Okay, going against it, we try to bring in confusion. So to ensure harmony in the legal system, judicial precedent is meant to decide what the law is and how it should be applied. Secondly, it provides reasonable certainty of law. Okay, when you go to court, you are certain that under certain circumstances or in relation to a particular material fact, this is what you should expect to get as your judgment. Okay, thirdly, it forces the citizens to conduct their affairs with some assurance of their standing in law. Yes, because it's as if a case that is similar to your own case has been ruled in the past. At least you expect what you should get in relation to your own case based on the similarity it has with the other case. Okay. Fourthly, it ensures orderly development of the rule of law, which automatically gives the Supreme Court the final power, suprema potestas, to decide, the supreme power to decide what the law is. If all the courts are allowed to develop the law by eliminating judicial precedent, then what the law is could potentially have different meaning. But due to the implementation of the judicial precedent, we all expect the Supreme Court to have the final say on what the law is, which is what we mean by ensures orderly development of rule of law. Okay, and then fifth, other courts are bound by the decision of the superior courts in the usual way. Usual, what is the usual way? That the cases are analogous in terms of material facts, in terms of similarities between the two cases in reference. Okay, so what then is binding precedent? Considering the fact that courts are hierarchically structured, decision of the superior courts are automatically binding on that of the lower court. And then that is why we say that precedent is then considered to be binding in cases where the issue or case under consideration in the lower court has similar material facts, similar circumstances, or empirical material with the decision that has been made or delivered in a higher court. Okay, so in that case, the lower courts are bound to follow and apply such precedents. Judicial rascality is said to occur where a lower court knows that there is an existing case decided by a higher court which is analogous in terms of material facts and circumstances to the case in consideration at the lower court, and yet decide not to follow the decision of the higher court. So decision of the lower court not to follow the decision of the higher court is simply what we refer as to judicial rascality, okay? However, to follow the decision of the higher court, it is essential to understand that that rule, that force is not automatic, because the lower courts still have the power to distinguish their own case from that of the higher court based on material facts, okay? So if the lower court sees that the present case under consideration is different from that case of the higher court, then it is not automatically bound to follow. It has the power to distinguish the two cases based on material fact and then rule its own decision. This was demonstrated in the case of Obiter Maritama Incorporated versus Rental Traders and Agencies Limited. Okay, so now let us look at Superior Courts of Record. Section 6 sub 5, paragraph 1, paragraph AI of the 1999 Constitution did list out, did enumerate the different courts of record based on their superiority. First, it highlighted the Supreme Court as the suprema potestas, the supreme power over all other courts. This is followed by Court of Appeal, Federal High Court, High Courts of the FCT Abuja, and then High Courts of a state. Okay, this is their order of hierarchy based on the 1999 Constitution. Okay, so when it comes to Superior Courts of Record, other courts include the Sharia Court of Appeal of the FCT Abuja, Sharia Court of Appeal of a state, the Customary Court of Appeal of the FCT Abuja, and the Customary Court of Appeal of a state. Okay. However, governments are also authorized to create other courts like the Magistrate Court, Industrial Court, Election Tribunal, and so on to solve particular cases. Okay. So now we look at Supreme Court. Supreme Court is the apex court of record, and its decisions are binding on all other courts. It is the supreme. It is the highest. Once a decision is reached at Supreme Court, you can no longer test it again in Nigeria, okay? Except if Supreme Court decides on its own to overrule itself, considering that it had made decisions per incuriam, okay? So if the Supreme Court sees that there are an issue or there are issues in relation to a particular case or decision which it reached by itself, it has power to overrule it. Okay, there are some cases in present-day Nigeria that could warrant overruling. For instance, the decision of the Supreme Court without prejudice, the decision of the Supreme Court that brought in Hope Uzodinma of Imo State as the sitting governor of Imo State, okay, which overthrown the then sitting governor, that's Ihedioha, okay, and did not award certificate of return to the second position. Instead, went to the third position. Okay, even if you say that the person that scored the first position isn't worth the seat, rightfully what to do should have been to award certificate of return to the second person, but their decision overruled the victory of the first and second and went to the third. On what ground? You know, so such decisions actually creates some serious lacuna in the legal system and the principle of justice, because it implied that if there were to be 10 contestants, even the 10th person can actually win. Logically possible, depending, but it is very difficult to believe such, okay? Then secondly, we go to the Court of Appeal, which was established in 1976. It is the next court in line after the Supreme Court, okay? And all of these decisions are binding on itself, one, and all other courts below it, okay? So where there are certain cases where the Court of Appeal is not actually bound by its decision. Number one is when it is faced with two previous conflicting decisions. Okay, it has the power to decide which one to follow. Okay. Secondly, when it is believed that such decisions cannot stand the decision of the Supreme Court, it has made a decision, but it is not convinced that the decision made by the appeal court, when tested at the Supreme Court, will stand. So it can decide to go against it. Okay. Then thirdly, when such decisions are made per incuriam, okay, then we have the third court in hierarchy, which is high courts. And when it was previously known as the Federal Revenue Courts, and its decisions are binding on all magistrates and district courts. When we talk about high court, we mean high court of the FCT and high court of all the states. They are in coordinate or concurrent jurisdiction. That is to say, the high court of a state is not higher to the high court of FCT, and the high court of FCT is not higher to the high court of the state. Their decisions on themselves are actually persuasive and not binding, but they are binding on all other courts below them, like the magistrate court, district court, and so on. Okay, you have the state high courts, of course, which we have already said has concurrent jurisdiction with the federal high court. Okay, and these decisions are binding on the magistrate court and other inferior courts. Okay, but not entirely on all matters. Yeah, why do we say so? This is based on the principle of federalism. There are certain things that might be a crime in Lagos State, but not a crime or an offense in Enugu State. So if it is said that the decisions of the state high court are binding on the entire cases or in relation to courts of lower jurisdiction, the implication is that that which is an issue in Lagos but not an issue in Enugu could potentially be made an issue in Enugu by virtue of the binding precedent. Okay, so in the spirit of true federalism, then what should rightly be said is that decisions of the state high courts are binding on the inferior courts within that state in relation to certain matters, okay? But they are not binding on other high courts. They are merely persuasive, okay? And then appeal from high courts actually lies on the court of appeal or appeal court, okay? Then customary courts of appeal. Both the customary courts of appeal of the FCT and other states have concurrent jurisdiction. What do we mean by that? They are of the same equal power. Okay, they receive appeals from the upper area courts and customary courts for the north and south, respectively. Okay, they deal on matters relating to custom and customary law, and they are bound by decisions of the higher courts. Appeal from these courts actually lies from decisions of the customary court of appeal. Okay, from customary court of appeal, it goes to the court of appeal straight. Okay, magistrate court and district courts. Based on what we have discussed earlier, states are empowered to establish magistrates and district courts. Okay, once that is done, the jurisdiction of that court is within that state, as we have said earlier. Okay, and its exercise of power is limited to its own magisterial district. Magistrate court of, if you come to Enugu, for instance, magistrate court of Agbani, its power is limited to the Agbani district. It cannot apply to the Nsukka district. The magistrate court of Nsukka is now in charge of Nsukka. Okay. Therefore, when in the northern part of the country, for instance, when a magistrate court is presiding over a criminal case, it is also known as a district court. This is why one judge can sit both at the magistrate court and also at the district court, depending on the case in view. If the case is civil, it is district court. If the case is criminal, it is magistrate court. So one judge can actually sit on the same bench and make decisions in relation to magistrate court and district court within the northern parts of Nigeria. But in the other parts of Nigeria, they are actually divided, okay? So they are both courts of inferior records, okay? Their jurisdictions are limited to both the nature of matter they can handle and the financial value of such a subject matter. For example, they cannot adjudicate on treasonable offenses, okay? Or competently determine murder cases. No, they can't actually do that. And the appeal from these courts is to the high court. Okay, any appeal coming from magistrate court or district court is to the high court. Okay, and then the high court is also said to have supervisory role over these two courts. Okay, which is why we say that in the north, one judge can actually sit in the two of them. However, if an appeal is raised from the magistrate and district court in the northern part of Nigeria to the high court, in such appeal, it is expected that two judges will sit on that appeal in the high court. Okay, then you have the customary court and the area courts. They deal mainly on customary issues like observation of customs like inheritance of an interstate estate or child custody, matrimonial causes, and other issues that have customarily binding. Okay, so and their jurisdiction is within the customary law, that particular location where they are located. Appeals lie to the customary court of appeal. Okay, you have the Sharia courts. Following the advent of the current civilian regime on the 29th of May 1999, many states in Nigeria have actually adopted the Islamic legal code and as such created the Sharia courts to administer the Islamic laws and dispensation of justice within that particular state. So Sharia courts actually deal only on issues that are exclusive to Islamic law, okay, between Muslims or any other person who submits to their jurisdiction. So, for instance, if you are Christians and you are living in the northern part of Nigeria that houses Sharia court, you are actually not bound to go to the Sharia court. But if you submit to the jurisdiction of that Sharia court, then the Sharia court can handle your issue if it has the power to look into it, okay? Its decisions are not subject to appeal. Once the Sharia court makes a decision, it is final. You cannot appeal that decision. Okay? So we have looked at the binding precedent. Now we are looking at persuasive precedent. Binding means that the courts are expected to follow. Persuasive, on the other hand, as the name implies, are persuasive in nature, based on the fact that the court that is considering such precedent is not obliged to follow or apply it. Okay? It arises when courts are mainly of equal ranking or coordinate or concurrent jurisdiction. So, for instance, the decision of the High Court of Lagos is persuasive to High Court of Enugu and vice versa because they are concurrent, they are coordinates in the jurisdiction. Okay? So in Skin Consult versus UK, the Supreme Court answered the question of whether a High Court can set aside an order made by a brother High Court in the same state by saying that it is the High Court from which the order complained of emanated from that can and must set it aside. Okay, not necessarily the judge of the High Court who originally made the order. So what am I trying to say? In this case, if you went to High Court A in Enugu State and an order was given, High Court B cannot set aside that decision or order of the High Court A. It is the High Court A that still has the power to set aside that decision. It's not necessarily whether or not the judge that made the decision was there. Even if the judge has been transferred, once the court is still there, the court is the one that has the power to set aside that decision. Okay? So, ratio decidendi. Ratio decidendi. This is the binding principle in a decision. What makes a decision binding is what we call ratio decidendi. It gives rise to a number of rules that must be followed. Okay? It is the accepted reason, the major reason why the court reached a decision. Okay, and judges are obliged to handle a case that have similar circumstances, similar material facts based on the ratio decidendi that was delivered by the courts in relation to the case in reference. Okay, so when a high court is looking to follow the decision of an appeal court, the high court is not actually following the judgment of the appeal court. The high court is following the reasons the appeal court gave for their judgment. That is the ratio decidendi, not the judgment itself. Okay, so what are the rules for finding a ratio decidendi in a case? First is the principle of a case is not found in the reason given in the opinion. Okay, the opinions of those judges that made that decision are not the principle. Their opinions are just mere obiter dictum, what they think. Okay, principle is also not found in the rule of law set forth in the opinion. Even if in making that opinion they reference a particular rule of law, you can't find the principle in that rule of law. Okay, so principle on the third note is not necessarily found by the consideration of all the ascertainable facts of the case and the decision of the judge. Okay, so all the cases that have been ascertained, presentations, pleadings, hearings, the main principle, the main ratio is not necessarily found. You can reference them, you can find them there, but they are not necessarily found in those pleadings. Okay, the principle in the ratio decidendi is actually found by taking into account, one, the facts treated by the judge as material. What are those facts the judge considered to be material? Two, the decisions that were based on those facts. Okay, the facts treated by the judges as material, decisions that were based on those facts. For instance, let's say a case of a custody battle where the father is pleading for custody of the child, and the child has been with the father. The father has been taking care of the child, education, and otherwise. Okay, if the court decides to award custody to the child to the father, based on one, that the child has been with the father, degree of familiarity. Okay, two, that the father has been taking care of the child since the child has been with the father. The ratio there is one, the degree of familiarity. Two, the fact that the father has been taking care of the child, not actually the award of custody. That's what we are trying to say. Okay, in finding the principle, fifth rule for finding a ratio decidendi. In finding the principle, it is also necessary to establish what facts were held to be immaterial by the judge. For the principle may depend as much as exclusion as it depends on inclusion. If the judge says that the fact that the child is of a tender age is immaterial, in as much as the child has been with the father for some period of time and the father has been taking care of the child, then the tender age doctrine becomes immaterial in that particular case, and as such is not, it has to be excluded from the ratio. Okay, how do courts treat earlier conflicting decisions? When courts are faced with two conflicting decisions, they are bound to decide on the one based on material facts to follow. Okay, so if the decisions are conflicting, then you now look at the material facts. Which one is more related or is more similar to the case in dispute? The one that is more related or similar is the one the court is bound to follow. Okay, what are the advantages of following a judicial precedent? Of course, there are numerous. One is the efficiency of a judicial function. Everybody is expected to do certain things based on certain established principles. It makes the legal process efficient. When you submit your case, you already know what to expect based on similar cases. Certainty of law, you know what to expect. Of course, predictability of law, you can say that based on similarity of these cases, this is what is predictable to happen. So in the case of Hope Uzodinma of Imo State as the sitting governor, ruled by the Supreme Court, if you came in as a third position candidate in your party during an election, that decision implied that you can actually have a chance of winning that seat. Certainty, predictability of law. It is not certain, but it's predictable. Okay, because it has been done before by the Supreme Court. Until date, the Supreme Court has not overruled it. So you can actually go to court and give it a try and probably become the governor of your state, even if you came in as the fifth person or seventh person during an election. Okay, 4, it ensures orderly development of the rule of law. It also allows for the development of law, generally by the Supreme Court as the Suprema Potestas, the final court, the apex court. 6, it ensures bulwark against partiality. Everybody are placed on the same pendulum of justice based on your material fact. Where the pendulum will tilt will depend on the degree, the extent you are able to convince the court with facts you submitted. Okay, it ensures equality before the law, flexibility, and of course great wealth of cases for legal profession, because you have a lot of cases to look at, to consider them in relation to the material fact with the particular case that you are looking into. Okay, so what are the disadvantages? It creates rigidity in the legal system because courts are bound to follow. If you are the High Court, you are bound to follow the Court of Appeal and Supreme Court. You cannot create your own law aside that which the Supreme Court or Court of Appeal have created. Okay, it results to illogical and technical distinctions in a need to deliver judgments based on a particular direction or to tilt the pendulum of justice in a particular direction. The court might venture into illogically separating material facts or applying technicality to invalidate an existing precedent in order not to follow that particular precedent. Okay, it leads to perpetuation of injustice. A governor or someone who won the 3rd position in an election can actually become the sitting governor continuously, perpetuation forever until the Supreme Court overrules it. Okay, then it leads to possibility of giving judgment per incuriam in error. Per incuriam means a judgment was made in error. There's also the case of accentuating the notion of law moving in a snail speed, because courts are bound to follow. They cannot shift, they cannot drift, they must follow existing precedent. It is bulky and complex, of course. These are the advantages. So what do we mean by obiter dictum? We have earlier said that it's simply the express opinion of the judge that was made by the wayside in the process of deciding a case, and it is wholly unnecessary for the decision. Courts are not bound to follow it. The opinion of the judge is simply an obiter dictum. It is merely persuasive and not binding. However, in the case of Nwana versus FCDA, the Supreme Court said via Toby JSC as it then was that it is actually a good law that over the course of a time, the obiter of the Supreme Court could assume the status of a ratio decidendi if it is continuously repeated. So if the 3rd person from an election can actually be given the certificate of return as the person who has won that election, if the Supreme Court continuously repeat it, at some point it could actually become a good law to stand in as a ratio decidendi. That is the position of the Supreme Court. Okay, so what do we mean by leading and majority judgment? Majority judgment is the position of the law adopted by the appeal or Supreme Court in reaching a ratio decidendi. Okay, what do we mean? Let me demonstrate. For instance, if 7 judges were seated on a serious constitutional matter in the Supreme Court, and majority of them, that is 4 out of 7, take a particular position of law, their decision is called the majority judgment. They will now appoint one person among them to write the majority judgment and also read it in the court. And this is what is called the leading judgment. Leading judgment is the judgment of the person appointed by the judges that make up the majority judgment. Then majority judgment is the judgment of majority of the judges in a particular appeal or Supreme Court case that tied towards a particular law. Okay, so for instance, let's take the case of Imo State again. Ihedioha versus Hopu Uzodimma. Okay, the leading judgment there is the decision that someone who came third can actually be declared the winner of an election. Then the majority judgment is that particular judgment which the leading judges who think that such should be the position of the law had appointed to write and read. So that particular judgment which we now adopt in court today is the majority judgment. Okay, and then the leading judge is the leading judgment, and the majority judgment is the fact that majority of the judges in that court adopted it as the position of the law. Okay, so now what is concurring judgment? A judgment is said to be concurring when it supports the leading judgments of the court. It simply has to amplify some areas not covered in the leading judgment, but is totally in agreement with the leading judgment. That is why a concurring judgment can actually be as simple as two words: I concur. The judge can just say, I concur, that the leading judgment is correct. Okay. On the same note, a concurring judgment can be cited by the leading judgment because it is not an obiter dictum, but a restatement of the ratio decidendi of the case. Okay? So, dissenting and minority judgment. In a nutshell, such judgment is said to occur when it does not confirm with the leading judgment of the court. It is a minority or dissent view from the view of the majority of the justices that constitute that court as contained in the leading judgment in relation to a particular case. Okay? Therefore, it cannot be relied upon as an authority in preference to the majority of the judgments of the court. Okay? So it cannot be relied upon. It is a minority judgment. Then unanimous judgment is a case whereby all the judges sitting on that case agree that this is the position of the law. There is no leading judgment, there is no minority judgment. All of them agree to one position of the law. That is unanimous judgment. Okay? Classification of courts in Nigeria. The most important classes of courts in Nigeria are courts of superior and inferior records, courts of records and non-courts of records, British type courts and non-British type courts. So courts of superior and inferior records, which we have looked at in relation to the binding effect. Decisions of the courts of superior records are binding on the courts of inferior records. Okay, these courts are classified into superior and inferior status. Superior courts are those that do not have limit in terms of the monetary value of the subject matter or litigation upon which they can entertain or adjudicate. They can adjudicate, they can listen to, they can hear any type of case. Okay, there are courts of unlimited jurisdiction, like the High Court of a state. Okay, so a superior court is not subject to supervision by another court. Okay, on the other hand, inferior courts have limitation in terms of the monetary value of the cases or nature of cases they can entertain or adjudicate. Okay, they are courts of limited jurisdiction and cannot exercise jurisdiction over matters outside their territorial scope or areas. Such courts are actually subject to supervision by the higher courts. For instance, the high courts plays a supervisory role over the magistrate court. Okay, such supervisions are through ways of prerogative writs of certiorari, prohibition, mandamus, or quo warranto. Okay, they tend to question the authority or power of that inferior court to act in a particular way. Okay, courts of records and non-courts of record. In a nutshell, court of record is one which its official acts and judicial proceedings are contained in documentary or enrolled for a perpetual memory and their testimony. Whatever the pleadings that are being made in the court are recorded. The court keeps all these records. The court makes use of these pleadings to reach a final decision. Okay. So in Nigeria today, virtually all the courts are actually courts of records because it's difficult. I don't think there's any court in Nigeria that doesn't keep record of whatever proceedings that is coming before that particular court. So generally speaking, Nigerian courts are all courts of records. Okay. British type and non-British type courts. Whenever we mention British type or anything British, it's in relation to the fact that we are colonized by the British. We cannot deny the fact that most of the things or majority of the things we do within the legal system are actually aligned with what is obtainable in Britain. Okay, so British type courts are those courts that follow after the model of British courts, both in practice and procedure. Okay, they apply English laws as the formal and the regular law in those courts, which is actually the case for most of the courts in Nigeria, except for the Sharia court. Okay? Examples of British courts are High Courts, Courts of Appeal, and the Supreme Court. Okay? Non-British courts are those that are indigenous to the Nigerian community. Even they were in existence even before the Europeans came, and they have continued to exist. For instance, when we talk about communal arbitration, Islamic court or Sharia court, all these things, customary laws, these things are the non-British type. They have been there since the existence of the country. Okay, what are the functions of the court? Number one is the court is responsible for interpreting law or statute. They define what law is their major function. Okay, they administer justice, of course, by placing the parties on the pendulum of justice and then tilting towards the direction that has a more convincing or more persuading material facts. Okay. Third, judicial control. They also ensure judicial control of the administrative organs of the state through the principle of checks and balances. That is why if you feel you have been robbed or that the electoral process was rigged, you can actually approach the court through checks and balances. They can determine whether the third person should actually go as the elected person. Okay. Four, they ensure protection of public morals by, of course, cushioning or awarding damages or punishment in relation to a particular case. People are more or less being dissuaded from engaging in such behavior because they expect that if they are found wanting, they would likely be punished. Okay, so at this point, we come to end of the lecture for today. Today, we have been able to look at what we consider to be judicial precedent and hierarchy of courts, which we say that judicial precedent is all about courts being bound to follow the decisions of the higher courts. Okay, we looked at major features of judicial precedent. One, it gives an indispensable foundation for deciding what the law is and its application, provides reasonable certainty of law, affords citizens to conduct their affairs with assurance, and ensures orderly development of law. Courts are bound by decisions of the superior courts. We looked at binding precedent, those that must be followed by the lower courts. We also considered courts of superior records based on the Section 6 sub 5 of the 1999 Constitution to include Supreme Court, Court of Appeal, Federal High Courts, High Courts of the FCT Abuja, High Court of a State, Sharia Court of Appeal of the FCT, Sharia Court of Appeal of a State, Customary Court of Appeal of the FCT, Customary Court of Appeal of a State, and the powers of the state to even create more courts. We said that Supreme Court is the apex court, court of the final decision. Appeal Court is second in line after Supreme Court. High Courts are third in line after the Appeal Court, and their decisions are binding on other lower courts. Appeal goes to the Appeal Court. Okay, this is the same for State High Court. Customary Courts of Appeal follow. Okay, Magistrate Courts and District Courts also follow as the most inferior courts. Okay, you have the Customary Courts and the Area Courts. And finally, Sharia Court, which deals mainly on Islamic laws or Islamic cases. and the decisions are final, but parties must first submit themselves to the jurisdiction of the Sharia court. So if the party decides that he or she doesn't want to submit his or herself to the jurisdiction of the Sharia court cannot entertain such a case. But when they so do, decisions of the Sharia court are final, okay? We have persuasive judgments, which occurs when courts are of equal or coordinate jurisdiction, like high courts of different states, okay? We have ratio decidendi, which is the major reason why court reach a decision, okay? The rules, number one, the principle is not in the Obiter, okay? The principle is also not set forth in the rule of law applied in the Obiter. Principle is not necessarily found in the ascertainable facts, okay? However, principle is found by looking into the facts that the judge considered and the decisions that were based on those facts, okay? So also in establishing principle, it is important to look at the exclusions, things that were excluded, not just things that were included, okay? Treating earlier conflicting decisions, the court must now look at which particular decision is similar, more similar to the present case, and that is the decision the court is expected to follow. Okay, advantages of a judicial precedent: efficiency of judicial function, certainty of law, predictability of law, ensures orderly development of the rule of law, allows for development of law generally by the Supreme Court, bulwark against partiality, equality before the law, flexibility, and great wealth of cases for legal profession. However, there are also disadvantages in the sense that it creates rigidity in the legal system, results to illogical and technical distinctions, perpetuation of injustice, possibility of giving judges judgment per incuriam, accentuating the notion of law moving in a snail speed and bulky and complex. Okay, Obiter dictum, simply the opinion of the judges. However, if the opinion of the judges is held over time in the case of Supreme Court, then it could actually assume the status of a ratio decidendi. Okay, you have the leading and majority judgment. The leading judgment is actually the judgment which was read before by the court. Then majority judgments are the direction or position of the law which majority of the judges in an appeal or Supreme Court case actually followed. Okay, concurrent judgment simply agrees with the leading judgment. Dissenting or minority judgment disagrees with the leading judgment. Unanimous judgment is where all the judges follow the same position of law. Of course, courts in Nigeria are classified based on superior and inferior courts, courts of records and non-courts of record, British courts and non-British courts. Superior courts are those whose decisions are binding on others. Inferior courts are those that have to follow the decision of the superior courts, okay? And then courts of records and non-courts of record. Generally, all courts in Nigeria are considered as courts of record because they keep record of their proceedings, okay? British type and non-British type. British type are those that follow British procedures, and non-British types are those that have been in place even before the Europeans came into Nigeria, okay? Functions of courts: number one, interpretation of law or statute, administration of justice, judicial control of administrative organs of the state, and protection of public morals. That is all for today. Thank you, and we hope to see you in subsequent lectures.